Bismillahirrahmanirrahim. Alhamdulillahi Rabbil Alamin. Wassalatu wassalamu ala Rasulillahi sallallahu alaihi wasallam. Assalamu alaikum warahmatullahi wabarakatuh. Welcome, ladies and gentlemen, brothers and sisters, to yet another monthly Shariah webinar series brought to you by Bank Rakyat, INSAF University, the International Islamic University of Malaysia, and Darasat for Research and Consulting in Islamic Finance, Islamic Banking. My name is Izzuddin, and as always, it is my pleasure to be your MC for our monthly session. And today we have a very interesting topic with a very capable speaker, inshallah. And today we will be speaking about Sharia non-compliance reporting of Islamic financial institutions, the necessity and challenges. With us today, we have Dr. Suhaimi Muhammad Yusuf. He is currently sitting on various boards of Sharia advisory boards of different institutions and a former Sharia specialist at Bank Negara, Malaysia. Now, before I pass the floor on to him, I would like to remind everyone that should you have any questions that you would like to pose to Dr. Suhaimi later on, please do fill in the Q&A window below, and then I will pose them to the speaker during our Q&A later on. And inshallah, hopefully, if Dr. Suhaimi permits, I'm sure this question is always asked. If we can have the slides later on, yes, inshallah. If Dr. Suhaimi says yes, I can email them to all our attendees. So without any further ado, I would like to pass the floor on to Dr. Suhaimi. Over to you, sir. Tafadhal.
Bismillahirrahmanirrahim. Wassalatu wassalamu ala Rasulillah wa ala alihi wa ashabihi ajma'in. Rabbi shrah li sadri wa yassir li amri wa hlul 'uqdatam min lisani yafqahu qawli. Subhanaka la ilma lana illa ma 'allamtana innaka antal alimul hakim. La hawla wa la quwwata illa billahil aliyyil azim. Assalamu alaikum wa rahmatullahi wa barakatuh, and good afternoon to everyone, to my colleague, and I think many my colleague attended this session. Maybe my colleague also can help me if in case there are questions that maybe particular to the relevant to them, inshallah. It is my pleasure to be here today in this webinar. Inshallah, with full barakah. Thanks to my brother Izzuddin as a moderator for this session, and to be the organizer, and to the organizer also who allow me to participate in monthly webinar series dedicated for Islamic finance discussion. I think this topic looks operational in nature, which I might not be able to provide and cover detailed operation of Islamic financial institution related to the whole process. However, as a first step for me in discussing this issue, I will cover in a broad manner that it might be interested to you, inshallah. I believe many of you here know better than me in terms of the detailed process of reporting of the SEC event. In today's discussion, I would like to explore and share with you a few key aspects. So then, how can I see the slide?
The slide is on screen.
Thank you. Yeah, thank you. In today's discussion, inshallah, I would like to explore and share with you a few key aspects, providing valuable insight, inshallah, if I can remember from previous working as a specialist in such a bank, that could help you, could help us better understanding why Sharia non-compliance reporting is a necessity and some challenges in completing this process. In my slide today, to begin with, basic understanding on what is Sharia non-compliant relating to Islamic financial transaction. Then to explain briefly why Sharia non-compliant reporting is necessary from both Sharia and regulatory perspective. and when the reporting taking place. After that, I will touch, maybe you can go to second slide. Yeah. Thank you. Then I will explain briefly why Shariah non-compliant reporting is necessary for both Shariah and regulatory perspective, and when the reporting taking place. After that, I will touch a little bit about the challenges in completing this process. Finally, I will share my thoughts in terms of moving forward, what we could do more to eliminate or at least to minimize the occurrence of SNC event, and eventually to prevent Islamic financial institution from any reputational risk and mistrust among the depositors or client and public at large, inshallah. Next slide. From IFSA 2013 and Hajjah PD, we find that Shariah non-compliant means any business, affair, or activity in a manner which is not in compliance with Shariah principle, or the advice or ruling of Shariah Advisory Council of the Negara, or the advice or decision made by Shariah Committee. This is a Shariah non-compliant definition, if I could say, very clear from what we have from the IFSA and Hajjah PD. And but even though we have the definition on the Shariah non-compliant definition, we actually try to look how the industry differentiate between potential Shariah non-compliant and actual Shariah non-compliant, because we find that in industry we have two kind of practice. I mean, the kind of definition, and maybe across the institution, different interpretation and different definition put in place. For example, potential Shariah non-compliant, some institution saying that operational lapse, and other because of system and so on. So what I can share with you from I took from one institution that they define PSNNC, any SNC refer to any SNC event detected and confirmed by officer within the control function, but pending decision by the Shariah Committee. Why they call it potential Shariah non-compliant? Because when it comes to the policy, internal policy, checklist, or anything governance maybe proposed to Shariah Committee and put minimum requirement on that, and then delegate to the Shariah officer or qualified Shariah officer and other relevant officer as a checklist.
Sorry, Dr. Swami, are you giving way for the Azan? Okay?
Yes, yes.
Oh, okay, it's Azan now. Okay.
Sorry for that. My phone ringing.
Okay, no worries.
Potential Shariah non-compliant refer to any SNC from internal perspective. When the officer discover anything not comply with the Shariah at their minimum requirement put in their policy, so they said that this call it potential Shariah non-compliant. And that this event, when detected, they propose to Shariah Committee, and for the Shariah Committee to assess further and deliberate. And once the Shariah Committee decided this SNC will become actual SNC. That's, I think, the differentiate how potential SNC and actual SNC being applied in the industry. Next, yeah. Why I say that Shariah non-compliant reporting is necessity. From my perspective, because we have two requirements here. From Shariah perspective, we have many ayah and hadith talking about the prohibition, and then in the transaction, for example, ayah from the Surah An-Nisa, يا أيها الذين آمنوا لا تأكلوا أموالكم بينكم بالباطل إلا أن تكون تجارة عن تراض منكم. O you who have believed, do not consume one another's wealth unjustly, but only business by mutual consent. So I think this ayah refer to the prohibition of consume another one wealth unjustly. So this the provision is very clear. And another ayah refer to the Surah Al-Baqarah. الذين يأكلون الربا لا يقومون إلا كما يقوم الذي يتخبطه الشيطان من المس ذلك بأنهم قالوا إنما البيع مثل الربا وحل الله البيع وحرم الربا. This is very clear, the prohibition of the riba compared to the permissibility of tijara or al-buyu and sale transaction. And another ayah from Surah Al-Ma'idah, يا أيها الذين آمنوا إنما الخمر والميسر والأنصاب والأزلام رجس من عمل الشيطان فاجتنبوه لعلكم تفلحون. This is related to the gambling and others kind of prohibited element. And from a hadith also we have many, but I quote here one hadith narrated by Muslim and others. عن أبي هريرة رضي الله عنه قال نهى رسول الله صلى الله عليه وسلم عن بيع الحصى وعن بيع الغرر. This hadith prohibit بيع الغرر, certainty or fraud in the transaction. And the second requirement from regulatory perspective, also if you look at the IFSA 2013 mentioned that where an institution become aware that it is carrying on any of its business affair or activity in a manner which is not in compliance with the Sharia or the advice of the Sharia committee or the advice or ruling of the Sharia Advisory Council, the institution shall immediately notify the bank and its Sharia committee of the defect, immediately cease from carrying on such business affair or activity and from taking any other similar business affair or activity, and within 30 days of becoming aware of such non-compliance or such further period as may be specified by the bank, submit to the bank a plan on the rectification of the non-compliance. That's from IFSA 2013, and from SGPD also provide a clear guidance. The Sharia Committee has the responsibility to provide objective and sound advice to the IFI to ensure that its aim and operation, business affairs, and activities are in compliance with Sharia. This includes providing a decision or advice on the operation, business affairs, and activities of the IFI, which may trigger a Sharia non-compliant event. Deliberating and affirming Sharia non-compliant finding by any relevant function, and endorsing rectification measures to address a Sharia non-compliant event. From these two, law and IFSA and SGPD, Bank Negara issue new guideline called operational risk reporting, replace, the supersede replacing the previous guideline, the Orion guideline. So I think the new guideline operational risk reporting is a very robust PD, and then having a clear system and a good system provided by Bank Negara, inshallah. But I think this is a very very key for the industry to follow. And then I think the OR PD provide very facilitative, inshallah. Next slide, Share. In terms of applicability, the OR PD apply to all financial institutions that offer Islamic financial business, including Shariah compliant e-money issuer. And under this PD, they provide a key expectation where reporting entities must ensure all operational risk events that relate to Islamic financial business to be assessed and reported appropriately. The SNC event must be reported by the product or business owner, regardless of where the event occurred. And the reporting entities are expected to ensure the overall management of SNC event, i.e. detection, confirmation, and rectification is expedited without any undue delay. The control mechanism to avoid recurrence of SNC event should be established. So these are 4 key expectations provided by negara in the PD. I think it's very clear that the industry need to observe very well. And then hopefully this PD could assist and then facilitate further how to resolve the SNC event when occurred, inshallah. Next, Share. Yeah, here I could share with you some step that we need to observe. For example, under the OR PD, they put a very clear expectation when time to report. For example, they divide by 3 stages. And firstly, when come to detection, for example, OWCF officer within the control function need to assess whether the event need to be tabled to SC for deliberation or not. And then discover potential non-compliant event, they need to lodge the report in the system immediately, inshallah. I think the officer in charge, I think they need to prepare in terms of what actually the proposal should be for the Shariah committee to be tabled to the Shariah committee. And then from that period, within 14 days, the officer in charge ataupun QSO maybe, relevant officer, secretariat and Shariah management, and the teams have to table to Shariah committee or Shariah advisor for deliberation. And this timeline specified in the OR PD very clear. So I hope that industry aware about this timeline, and I think the practice has been done, and the industry also doing rigorously, and the gap assessment and so on. So because when I discover the checklist provided and governance provided, internal policy prepared by the industry looks very robust currently compared to the previous one. So within the timeline, the detection period, so officer in charge need to table to SC for deliberation. And after tabling the issue to the Shariah committee, so Shariah committee need to confirm whether the event proposed by the officer is actually actual SNC or remain potential SNC or none related to Shariah non-compliant. So within this period, the ORPD is silent about how long should be taken by the Shariah committee to decide. But when I discussed with the officer of the negara, they said that even though not really stipulate timeline, but they will monitor. I mean, the Bin Negara will monitor about the process and also the development of this kind of event. And the officer said that the time should no be longer than the 6 months. I mean, from Shariah perspective, we need to see the event, whether this event going to be affect the institution in terms of reputational risk or not. And from Shariah perspective, Shariah committee need to see that any non-compliant matters should be resolved immediately. Because if we have malul haram, for example, we need to immediately cease or immediately channel out to the charity. For example, if discover that potential Shariah non-compliant going to be actual. So from fatwa and Shariah opinion, scholars view that ikhraj mal al-haram should be immediate, fauran, tidak boleh, cannot delay. So once the Shariah committee confirm the potential Shariah non-compliant is actual, so within that period, the officer in charge need to update immediately in the system. For example, in the system, maybe need to tick whatever relevant for the to indicate that potential SNC become actual SNC. So from this moment, the process going to further for board approval, and then together with the ratification plan provided by the team and also Shariah committee endorsement. So I think to be safe here, when it comes to the deliberation at Shariah committee, the officer in charge should prepare also the proposed ratification plan, because I think without the proposal, maybe the deliberation is going to take longer and then affect the timeline given by negara. And once the Shariah committee deliberated the ratification plan, and board need to approve or endorse the ratification measures, and within the 30 days period, ratification plan submission in the art system need to be from the period, I mean, from board need to approve ratification plan as endorsed by within 30 days. I mean, from the Shariah committee endorsement, time to be taken should not be more than 30 days. So I mean, the management and also the officer in charge need to manage very well this timeline so that going to not going to burst the timeline. So Bank Negara quite sensitive in terms of timeline here when it comes to the Shariah compliant event. That's I think I can share this stage provided in the OR or PD. So hopefully industry would comply with these requirements, inshallah. And all three stages, many things happen, and I think maybe this time cannot unable to share everything because maybe some certain industry have certain experience, and for the other they face maybe different experience at all in terms of handling a Shariah non-compliant event. Next, please. Here, maybe I could share some challenges when it comes to the Shariah non-compliant reporting. For example, we find that some institutions still require continuous training for the staff and regular engagement so that the institution prepared their staff with the understanding, clear understanding on the Sharia related matters. These challenges, I think, very more going to be maybe bigger for the institutions that have conventional parent or leverage model compared to the full-fledged, because they leverage on the staff that also doing both conventional and Islamic. So continuous training must be there, and whether there is structured or non-structured training for the staff. So this hopefully by a rigorous training or regular engagement with the Sharia officer department, the staff that handle the business line and others can, I think, surely can manage the Sharia non-compliant matters properly, inshallah. And the second one, I discovered that internal policy developed by officers also facing great challenge. For example, setting or developing minimum requirement or parameters for each and every product offered consistent with basic Sharia principle. For example, developing Sharia screening checklist for financing type of product that have diverse Sharia contract, which some of Sharia contract require monitoring in terms of business activities by the client. What I can say here, the example that I provide here, for example, checklist for the product that relevant to bank transaction, sale transaction, especially on tawarruk transaction. So maybe the requirement for monitoring perspective is not really require compared to the product that using the underlying contract is ijarah or equity-based transaction, because that kind of contract, ijarah and equity-based, is actually the asset belong to the institution. So the institution need to monitor whether the business activities still comply during onboarding and also during the tenure of the financing period. So this kind of parameters, some of the institution maybe they don't foresee this very critical for them. But looking at the current situation where Bank Negara always monitoring and always supervise, and looking at the how financial institution develop the audit to see the compliance of the activities of the client when a financial institution giving the financing, because this is always look at the IFSA, for example, the activities and business, the aim and operations need to be Shariah compliant at all time. So this is a very hard to defend when the institution itself, they don't have a monitoring mechanism. For example, especially on the ijarah and also equity type of contract. The second one, sufficient guidance by Shariah Committee and management in developing robust internal policy that include every single step and action. For example, if I can say on the simple parameter or simple kind of aspect, disbursement of tinted income. If we look at the if we look at the current perspective, when we have for institution found that tinted fund need to be channeled immediately. So the parameters or checklist that or SOP that provided by the institution just very simple, just disbursement and immediate disbursement of tinted income. But they don't realize that Bank Negara also observe and assess whether disbursement of tinted income not going to be benefited to the institution itself. This is very critical, because in terms of tinted income, the institution cannot benefit, direct or indirect. That's from the regulator's perspective, and also from Shariah. So we need to have a clear parameter, bit here, whether how we can actually avoid this kind of benefiting to the institution from the tinted fund when disbursed to the other or third party, maybe third party related to also the institution itself. And possible also that some whether when we disburse the tinted income or tinted fund to the other institution, third party, whether need to declare that the tinted income that they receive from us actually the tinted income, whether we need to declare or not. This also kind of element that we need to consider to put a dawabit clearly, because some institutions, they don't actually receive or accept the tinted income disbursed to them, because for their institution, they only receive the clean money or kata apa halal fund only. So this is I think kind of very sticky, a very kata apa hassle, because although we see a small matter, but implication is very big. So we need to be more careful on this. And the third one on the system, this is always, I think, all the institutions or many of the institutions need to consider upgrade the system or modify the system so that the system is in line, always in line with the Shariah requirement. because sometimes because of system they cannot do the transaction, and because of the system they do manually. So when the industry doing manually, they invite more risk, Shariah non-compliant risk to the institution. So be careful on this, and hopefully the industry can understand. Although the system actually require a big kata apa, budget, but for the long term, and then to manage SNC, the system need to be robust and equipped with the Sharia requirement as well. And third, the fourth challenges, sufficient resources in place. To have enough competent resources for each organ of the control function also become challenging, because maybe some institution see that one person for Sharia compliant, one person for Sharia risk, and 1 or 2% for Sharia review, or maybe Sharia review currently most institutions actually provide more resources on that. But on the risk, Sharia risk management, they don't actually pay attention on this. Be careful that Bank Negara looking at this critical, very crucial, and then the institution need to pay more attention on this to have a competent and also enough resources put in place for all control function, so that they can play their role to minimize or eliminate the Sharia non-compliant risk. And the fifth one is very interesting aspect when come to the Sharia non-compliant event. So Sharia committee need to deliberate on the rectification mechanism. We can see that this practice actually still lacks standardization across the industry, because industry A doing differently when involved the similar aspect with the other industry. So similar case with different kind of rectification plan and measures. So I think this is going to be also risky as well, and difficult to manage. And then also I think it's require for Sharia committee to deliberate, require full disclosure of SNC case or event by the management and relevant officers or control function. Without full disclosure, maybe Sharia committee will decide differently, and then not really cater the issue properly. And when come to the Bank Negara assessment letter, or whether through thematic review or maybe through reporting, quite difficult for Sharia committee to manage, because normally when come to the rectification mechanism or Sharia non-compliant event, firstly, using the current PD, all timeline and reporting clear. But when come to the rectification mechanism, for example, Sharia committee may decide differently and then not satisfy the Bank Negara with the decision, and Bank Negara coming in and asking about the what happened and why the decision, why they don't have Sharia rationale, and so on, why rationale is differently, and different decision related to similar occurrence or similar cases. So this is very critical for Sharia committee to deliberate and decide. Without full disclosure, I think it's quite hard. And sometimes for Sharia committee also, made decision without any proper basis, Shariah basis and rationale. So quite challenging as well, and then quite risky because sometimes Shariah committee opinions is different compared to Bank Negara and SSC opinion. So when it comes to this issue, normally Bank Negara will ask Shariah committee to come and then present their case and share their views, so that Bank Negara wanted to confirm. Normally, if Bank Negara call a Shariah committee, need to be careful lah. Kalau kita kata apa, Shariah committee actually cannot handle the situation and cannot actually deliberate the issue properly, and maybe Shariah committee they don't understand fully the issues, very dangerous. So make sure that Shariah committee comprehend all the issues, Shariah issues and Shariah non-compliant issues, and also how the mitigation being made, and the Shariah rationale and Shariah basis as well. Without that, maybe going to affect Shariah committee also in this case. So to me, ratification mechanism is not really difficult if Shariah committee have full disclosure on the issue and deliberate with the deliberated properly lah. And the lastly, in terms of managing the impact of SNC on IFI, this is also quite critical because non-compliant actually involve going to be maybe financial risk, financial losses, and also reputational risk to the institution itself, and maybe fall under the penalty, for example, require institution to consider the administrative penalty from Bank Negara, for example. So I think the impacts actually quite huge here on the SNC, so that Islamic financial institutions need to observe and need to have robust internal control and internal SOP, internal policy, governance, and so on. So hopefully that institution need to take this seriously, not really kata apa macam take it for granted. This is quite critical lah. Even though kita kata apa Bank Negara when they issue ORPD, they facilitate a lot financial institution how to manage the SNC. And the impact also on the SNC maybe need to look at the internal framework as well. For example, consequential assessment framework on the officer who is responsible for the SNC event. So need to have kind of internal policy how to manage the officers that responsible for the SNC event, whether the actually lack of knowledge or taking for granted and whatsoever. So what actually going to affect that officer? We have to, institution need to have that framework so that can easily respond to Bank Negara properly lah. Without that, maybe Bank Negara taking action on the officer. This one, if you look at the positive side, SNC event, if we actually discover not because of people, but because of system, and maybe because of the unclarity, not clear in terms of Shariah decision, for example, I think can be manageable. But in terms of lack of knowledge of the officer and what more on the fraudulent side, because some institution when it comes to the SNC, they try to making something that to them maybe they try to rewrite the agreement, or maybe they need they try to rewrite the contract and so on. So this is fall under the fraudulent perspective. So Bank Negara will see this seriously, take this seriously, and going to be impact more to the institution. So better to resolve within the institution with a Shariah committee how to rectify, and then to manage essentially event properly, insyaAllah, without kita kata apa, jujur bercakap betul lah, ya kan? Jangan cuba pusing-pusing. That's very critical. Next, Sheikh.
Very good. So, Sami, can we wrap up in 2 minutes, because we do have to give time for Q&A.
Yes, yes, sure. Just I go through quickly on the suggestion and recommendation here. So to me, to minimize the occurrence of Shariah non-compliant, I think it's better to have more standardization of practice across the industry, especially matters related to ratification plan and mechanism for actual SNC event. To provide a dedicated database of SSC ruling and SC decision in the form of a digital repository as reference to maintain consistencies and compliance with Sharia. Third, setting a minimum qualification, for example, and experience for qualified Sharia officer with a proper training to be completed within a certain period of time, and to provide a clear expectation on the resources required for each control function of IFIs, especially for leverage model institution. And lastly, this is a very critical, embracing and practicing Sharia compliant culture across the organization. But top-down approach is, I think, quite kata apa, effective to me. If we look at the across organization, and then, for example, under the leverage model from the parent company of parent institution, that they also aware about the Sharia compliant. So this that's all from me, and inshallah, hopefully this very brief and broad manner in terms of Sharia compliant reporting to share with you here today, hopefully beneficial to you and to me as well. Jazakumullah khair. Assalamualaikum warahmatullahi wabarakatuh.
Wa alaikum salam wa rahmatullahi wa barakatuh. Jazakallah khair, and thank you very much, Dr. Suhaimi, for that very informative session. So now, ladies and gentlemen, brothers and sisters, I would like to open the floor for any Q&A. First, I would like to allow our panelists, our other panelists on the call right now, on the webinar right now, to pose any questions to Dr. Suhaimi. Please just unmute yourself, and you can ask your question.
What are some mechanisms that can be implemented internally to mitigate international SNC? I read the question, Sheikh. I can't hear you. I can't hear you, Sheikh.
Sorry, can we let the panelists first?
Yes.
If anyone from our panelists, Ustaz Zamiri or anyone else, Prof. Azman, if you'd like to add any question. If not, we will move to the audience questions. Salam.
Very much, Azuddin. First of all, I'd like to thank Dr. Suhaimi for his time today to share with us his wide experience in the industry. And actually, he got the credit when it comes to, you know, I think we can regard him as the engineer for this SNC reporting, which is part of the Sharia governance framework. Jazakallah khairan kathiran. And it's a very, actually, as he said, robust and very comprehensive mechanism. I have one question. What happened in the market is, the thing is, for the management, most of the management what is taken into consideration is the amount of money to be purified. So some of them they try to rectify. I mean, any SNC events, Shariah non-compliance events. For example, in the case we overcharge the customer and then we refund it to the customer. Should this be regarded as SNC, or SNC only you can classify it as SNC when there is a breach of the Shariah requirement in the contract? For example, the absence of the commodity for tawarruk, or the absence of the selling price, and then after the end of the financing tenure, for example, the bank already, I mean, there is no chance for the bank to refund the money. So I think this is what is happening in the industry, because the players in the market try to reduce the number of the SNC amounts. To them, this is KPI. To them, some of them, they say zero tolerance to SNC. But we are human beings. You know? There are always mistakes. Sometimes we do not, I mean, make mistake intentionally. It could happen, you know, human errors. But still, I mean, there is, you know, the push from the board, for example, try to avoid, try to disclose, and try to resolve it, try to rectify it, you know, and not to declare it. But Dr. Sami was mentioning something which is very important, which is about the reporting process, where it must be made known, so that and also the rectification plan must also be made known, and whether it already rectified, it must also made known. So maybe that particular issue, Dr. Sahimi, they want to minimize, you know, the findings, the SNC amount. What do you think? Is there any means, you know, we can, you know, control it? Jazakallah khair.
Hayakumullah, Sheikh. Very, very interesting question, Prof. Azman. I think when it comes to the SNC matters, so that, for example, overcharge to the customer. So when it comes to the deliberation, I think Shariah committee should see from what angle overcharge be done, and then whether overcharge actually through not reflecting the contract or not. But normally overcharge could fall under SNC as well. But then how to rectify the matter depend on how the Shariah committee see it lah. But from Shariah perspective, when you overcharge the customer, the fund overcharge should be returned back to the customer. That's the adalah type of perspective lah. Should be returned back to the customer, unless there is other consideration that the Shariah committee need to decide. And how your second question about the reducing the amount, I think the Shariah committee, they don't actually really look at the reducing the amount, because whether the amount actually considered under the mal haram or not. That's the from Shariah committee perspective. If mal is haram, the bank or institution cannot actually reduce the amount, because they need to channel all the amount, prohibited amount that cannot be recognized by the institution. So actually, this one is very clear. But depending on how Shariah committee can consider reducing the amount, whether halal actually whether in the total amount actually there is halal proportion, halal percentage, small percentage under the same amount. But if total amount is considered haram, they cannot accept the reducing. I mean, cannot reduce. Need to channel all the amount. That's from my perspective, yes.
Thank you very much, Prof. Azman. I believe we have a question from Professor Dr. Rusdi.
Thank you very much. Terima kasih, Pak Lee. Encik Azudin, Dr. Suhaimi. Yeah, my question is actually pertaining to, because I think what you have explained about the Shariah compliance, SNC reporting and whatnot is good. And then we are adopting it. There are some challenge and whatnot, but I think it's a continuous growth and then continuous enhancement that we are doing. Now, my question is more on moving forward in terms of the what we call it, non-banking and financial institutions under Bank Negara, in terms of adopting the processes of SNC and whatnot, because we understand that now, for example, SKM is in the process, and then this is the initiative under CCOB. Yeah. So moving forward, then there will be more institutions which are not banking and financial institutions under Bank Negara, that are so used with so-called Bank Negara regulation and whatnot, but they are different. But now, how are we going to apply this in the context of them? They are not familiar, they are not properly highly regulated before. And then how should we, should the approach be the same? The point is simple for them, or it should be more flexible and then kind of a bit more compromise in terms of the processes and whatnot. Thank you, Dr. Suhaimi.
Yeah, Prof. Dr. Rosni. For other institutions that don't really regulated by Bank Negara, they can adopt the mechanism, I think, but the system may not be eligible for them lah, because the system actually for the financial institution and also the macam few institution that they govern under Bank Negara. The main, for example, 3 steps that I mentioned previously, Dr. Rosni. So they can adopt all 3 stage that we have, because without 3 stage, I think it's quite difficult to manage the rectification plan, and also to identify each of the flow of the transaction. For example, when it comes to detection by the officer, and then what actually officer need to do with this detection, and then come to the proposal to Shariah committee to deliberate. So I think maybe the flexibility that can play by the institution not regulated by Bank Negara in terms of keeping the date or detected date, for example, but can do it manually, Prof. Rosni. And then the deliberation and also rationale by the Shariah committee need to be put the proper manner. But the deadline, for example, within 30 days and 14 days, I think this one maybe could be flexible compared to the regulated financial institution. Personally, thank you. So, sorry if I...
Shukran. That's very, very insightful actually, because we are in the process of doing that. So we take that. I think the processes must be there. As you are suggesting that the 3 main or fundamental process must be there, but implementation details may be slightly different. Thank you very much. Really appreciate.
Thank you very much, Prof. Rosni. I think we can get to the questions from the audience. There's already 9, alhamdulillah. So the first question asks, what are some mechanisms that can be implemented internally to mitigate internal Shariah non-compliance?
Yeah, I think the ORPD, Chair Azudin, and refer to this, person asked about this question. The ORPD facilitated well in terms of how to to mitigate the internal SNC. But to me, if you have a proper internal policy and also rigorous assessment by the officers in terms of when it comes to the product product implementation, for example, I think with the robust governance and policy internally could mitigate better with the competent officer in charge of the business aspect, inshallah. So let's say, for example, institution that have control function, for example, risk management, they need to have Shariah risk officer over there so that they can, from beginning, they can participate in terms of discussion or developing product and so on. So from the beginning, actually, Shariah risk officer can actually mitigate when they have actually good knowledge on the Shariah. So that I think when it comes to the risk management, some of the financial institutions fail to have a good person in charge because they leverage on the conventional. So that's timely for the institution to develop expertise or human capital inside that good knowledge in terms of Shariah perspective with the risk management perspective. Okay.
Okay, then next question. During the detection stage, how does OWCF differentiate between an event need to be tabled to SC or not?
Normally, the officer in charge, when they discover the potential Shariah non-compliant, normally they try to measure against the checklist that they have. If they actually fall under the checklist internal policy or parameter, so they can bring to the Shariah committee for the deliberation. So actually, the process on the detection through the internal policy that they have checklists and SOPs. Thank you.
Thank you. Next question. Thank you for a very clear presentation, Doctor. I have two questions. First is about to give service to non-Muslims, for example, i.e. bank make a service to write a will to non-Muslim customer. Do those activities will contravene, I guess, with IFSA or off SNC activities? Do you think there is a need for BNM to make standard policies for IFI to deal with non-Muslim recognized entities or communities in Malaysia? And second question, what is the regulator's stand on the operational aspect of straight-to process in determining the compliance status for the applicant? Is it enough to depend only on one company declaration?
The second question is really hard for me to answer because it's from regulator's perspective. But if I can,
first one.
but if I can answer on the second one, maybe the institution need to engage further with the Bank Negara, closely engage with the Bank Negara, how they see on the digital type of perspective of product that maybe to embrace the current development on the digital so that customer can have minimal time turnaround time for them to have a financing product from the institution. So possible that the aspect that institution need to look at how robust the mechanism put in place for the client to apply for the digital kind of straight-through product. So the process need to be more robust from the regulator perspective. I think they need how robust that mechanism provided by the institution for a client to understand this whether declaration by the customer is sufficient or not. On the first question, I think the will service to non-Muslim, because non-Muslim is different, they governed by the civil punya governance, so maybe different perspective, and I can't actually give views here because there are different opinion among the scholars as well whether they can provide a service or not. But what I can say for the Islamic institution, they need to see internally to have the Shariah committee deliberation and decision on that part.
Okay, another question. Based on your view, can a company channel the tainted income to its own charitable organization? That's interesting.
Cannot, because these actually will indirectly benefited them. It's very clear because to me, how to assess direct and indirect. But this one, very direct, so cannot be.
Right. Okay, ladies and gentlemen, in the interest of time, we have another, we actually gone over time, but we do have another 11 questions. So I guess I will leave Dr. Suhaimi to choose the questions in the last 5 minutes, I guess. If you don't mind, Doctor. Boleh,
yeah?
Because I don't think we can address all 11 questions, unfortunately.
Yeah.
So I'll let Dr. Suhaimi choose.
I try to understand the Assalamualaikum. Thank you for the knowledge sharing with regard to the suggestion, recommendation, item number 1 and number 2. Would that be under Bank Negara SSC initiative for industry players to make reference? Number 1, number 2.
Number 1, number 2. Let me back.
Sorry for that. I confused something.
Sure. Let's see.
Last recommendation.
This one?
Yeah, I think this suggestion could be played by the maybe the institution like IBIM, for example, for the number 1, and number 2, possible that Bank Negara together with Zasri to provide that database, or possible that Bank Negara also, if IBIM can propose that so that Bank Negara can take care. But I don't know whether Bank Negara also can also put in place the Shariah committee decision in place in the database. But for if we look at the only Shariah ruling, SSC ruling, possible that Bank Negara can take this on. But together with Shariah committee, I prefer that the industry should be one to play a role to drive this project. Thank you.
You?
Sorry, I saw that there are many questions I cannot actually maybe answer. Maybe next time, as you did, inshallah.
Sure. Okay. Thank you so much, Dr. Suhaimi, for that very engaging session. And thank you once again, ladies and gentlemen, for tuning in for this monthly webinar series. And thank you for all your questions. I do enjoy a webinar with lots of questions, but unfortunately, we've run out of time. We've gone over time. So on behalf of the organizers, my name is Izzuddin. It's been a pleasure to be your MC and moderator for this session. So see you in the next monthly Sharia webinar series, inshallah. Assalamualaikum warahmatullahi wabarakatuh. Thank you.
Assalamu warahmatullah.
Thank you, Izzuddin. Thank you.
Thank you, Dr. Suhaimi.
Thank you, Sheikh.
Thank you. Assalamualaikum.
Assalamu warahmatullah.